Welcome to the EPG Pathshala. This paper is the philosophy of law. The module is Gandhi and Law. The objectives of this module are to understand Gandhi's idea of law and legal practice. This module was written by Arvind Narayan of the Alternative Law Forum, Bangalore. I'm Akash Singh Rathore from Lewis University in Rome. We'll start with Gandhi's critique of law because that's what people are most familiar with, and conclude is his final position on the role of the law. In Hind Swaraj, Gandhi wrote, "The lawyers, therefore, will, as a rule, advance quarrels instead of repressing them. Moreover, men take up the profession not in order to help others out of their miseries, but to enrich themselves. It's within my knowledge that they are glad when men have disputes. Petty pleaders actually manufacture them." So Gandhi's critique is not unlike what we've heard in Plato's Republic, the Socratic critique of the lawyers, that lawyers are not very healthy for society. They foment disputes and they attempt to enrich themselves. And Gandhi is quite categorical about this in Hind Swaraj. He goes on to say that the greatest injury that the lawyers have done to the country is that they have tightened the grip, the English grip. Do you think it would be possible for the English to carry on their governments without law courts? So this is the sense that we get from Hind Swaraj. By this time, Gandhi has stopped practicing law himself, and his critique is quite damning about the role that lawyers play in society. But is that really the final word, the last word that Gandhi has to say about the law and the legal profession, legal practices, and the relationship between law and justice? In this module, we're going to attempt to read beyond Hind Swaraj and suggest that Gandhi has further contributions to make in terms of what the law is, what the benefits of the law may be, and how people can use the law to pursue ends more noble than those he outlined in Hind Swaraj. So what is the work that we are talking about that Gandhi had done that goes beyond the critique within Hind Swaraj? There are basically four kinds of work and writing and practice that we wish to mention. The first is his contribution to civil rights in South Africa, where Gandhi basically donned the role of a human rights lawyer. The second is Gandhi's contribution to innovating socio-legal activism by authoring the first human rights report that we know of in India. It's called the Fact-Finding Report in relation to the Jallianwala massacre that occurred in the Punjab. The third is Gandhi's contribution to the field of legal journalism, where the newspaper that he publishes, Young India, becomes a vehicle to denounce injustice more broadly. And the fourth is Gandhi's use of the theatrical potential of the law in order to challenge the colonial state. The theatrical potential refers to the way that when a trial is going on, the people who are in defense in that trial, the defendants of the trial, have the opportunity to speak, and often there are reporters recording what they say, and this occasion of the defendant articulating the reasons for his actions in relation to the present authorities there has a certain theatrical quality that can serve to spread the message being articulated by the defendant. So let's begin with the first, Gandhi as an early human rights lawyer. After getting his law degree from the Inner Temple in England, Gandhi attempted the practice of law both in Rajkot and in Bombay. He wasn't too successful in finding a practice that he was comfortable with, so when an opportunity arose to go to South Africa to provide legal assistance to a client, he took that opportunity very happily. what he found in South Africa was the difficulty of getting equal treatment for the various communities. The one he was working for were obviously the Indians. And Gandhi's legal practice began to get much more subtle and refined in this process of functioning within a law court where the idea of justice was one that was distinguished upon racial lines. So racial justice, different kinds of justice meted out to different races. In that process, Gandhi moved from being the lawyer who got his clients released on bail to being the one who was himself accused, being the defendant in the case. This happened because as he was practicing law, he realized that the legal system was patently unjust, and he took it upon himself to begin to transgress those laws and find himself to be the alleged criminal needing defense. Now, in the range of his legal practice in South Africa, the work that Gandhi did was not different at all from the kind of work that human rights lawyers, practitioners undertake today. However, where Gandhi went well beyond the role of human rights lawyers was when he became a satyagrahi, not just a practicing activist. Now, we move on from this situation in South Africa, where we see Gandhi's legal practice as one that informs him about how to deal with racial injustice, how to negotiate with law courts, how to stage the theater of legal and juridical trials, and several other lessons that would prove extremely important to the way that he conducts civil disobedience later in his life. We move from these legal innovations in South Africa to the innovations in social legal activism that he undertook through what's called fact-finding reports. An excellent example of social legal innovation is the report that was prepared by the Congress Party in the wake of the Punjab disturbances in 1919. Following the Jallianwala Bagh massacre, Congress decided that they would undertake a fact-finding report. Now, what is innovative or revolutionary about this? Obviously, following this massacre, the British government itself assembled a commission to look into the massacre, what happened, why it happened, and how to prevent such things in the future. But in this respect, when a government is establishing a commission to criticize itself, two things happen. One is that we cannot rely on the veracity of the conclusions that are found in this fact-finding commission, because everybody is part of the dominant. And the second point is that when a government examines itself, it establishes its own monopoly on the truth, and nobody else has access either to the truth or to other sorts of facts that would allow them to challenge that truth. By the Congress Party boycotting the government's own commission investigating the massacre, it established the possibility of an alternative truth, a rival conception of truth, and thereby destroyed the government's monopoly on the truth. Another thing that this fact-finding report did was to take the basic premise that the British would articulate about this massacre, what Churchill referred to as an event of sinister, singular isolation, and be able to frame this massacre within the larger history of British colonialism. So while the British would like to say that this massacre is an exception and this is not how we operate, by the Congress Party commissioning its own fact-finding report led by Gandhi, the possibility arose to actually reframe this massacre not as an isolation, but as a logical consequence and a logical result of British imperial policy in the Punjab. What is innovative about fact-finding is not simply that it provides an alternative truth that can be used to deconstruct the monopoly of truth that the government has when it presents the facts of what happened at something like a massacre and attempt to justify that massacre. The innovation comes in the way that this body of knowledge can be used by lawyers or advocates in bringing to trial cases that otherwise would not be able to be brought to trial, considering that it's the state that has the monopoly on the events, or their version of the events that occurred. So this fact-finding report became the paradigmatic method for NGOs, human rights activists, and other sorts of activists in order to challenge the information being released by the state or put out by the state, whether through press reports or through the media. And in subsequent Indian history, the fact-finding report has been crucial in transforming the way that defendants of crimes or advocates for the increase of political liberties can justify their position or establish their defense. Some simple examples of this are there in relation to the environmental practices of the Indian government, hand in hand with certain mining or logging companies. Fact-finding reports are routinely conducted by environmental activist groups, or in the case of the Bhopal disaster, the fact-finding reports were crucial in informing the wider public about the realities of the event, contrary to what was put out by the corporations and by certain sectors of the Indian government. So fact-finding is a means of empowerment and a means of providing a kind of challenge to the monopoly of the truth that the state claims to possess. This is a legacy of Gandhi's education in law that has proved quite important for all subsequent human rights advocacy in India. Let's move on to law as journalism. Here's another case where Gandhi innovated the use of media, print media, and employed his legal training in order to effect large-scale political results. While Gandhi had already started the publication of a magazine in South Africa called Indian Opinion, it was really with the publication of Young India after his return to India where the legal training that he had received in the UK and the legal practice in South Africa allowed him to articulate the cases that he wanted to disseminate through Young India with a poignant clarity and at times a peculiar silence. What is this silence about? Sometimes people would complain that Gandhi is not covering an important event in Young India that he should be covering. His reply was that he didn't have all the facts. This is a clear product of his legal training. You don't make claims that you cannot support by evidence. For example, take the massacre that we were just referring to in the previous section. Gandhi was quite silent about this in Young India for a fair amount of time until the results of the report started coming in and these facts were verified independently. Once he had the facts, he flooded the paper, Young India, with a number of accusations against those who committed the crime and a number of exposés of the way that the government was covering up the true heinousness of this event. So what Gandhi is doing through this exposing these injustices in Young India is he's taking law outside of the courts, the legal judicial courts, and he's moving it to what is called the court of public opinion. So he's using legal argumentation supported by evidence and legal reasoning. And instead of going to the court and presenting this, he's presenting it widely to the court of public opinion. He's motivating the public about the injustices that are being faced by people in relation to what the government is doing. And this is a clear example of the way that law has served post-Hind Swaraj Gandhi's mission. Now there's something very interesting to be pointed out here. It's interesting for all of legal theory and legal history, and we have Gandhi to thank for making this discovery. This is about the difference between procedure and substance in terms of legal activism. Now, in Gandhi's legal writing that he undertook in Young India, he makes a very strong case for following procedure. So where does this idea come from? Now you remember that when Gandhi was practicing law in South Africa, he realized that justice was racialized. So different races were subject to different modes of justice. Now, just by very definition, that is injustice. However, the British law and the British rule in South Africa permitted this sort of injustice substantively. So substantively means the body of the law was determined by different races, and who got what was, what punishment was meted out was determined by different races. So there was an unjust substantive law. However, the British legal tradition has always been grounded in the natural law tradition found in Roman times. So Roman law was based in what's called a natural justice jurisprudence. This suggests that there are certain principles of law that can never be violated. These are called procedural principles. So the procedural principles include things like the party who is to be punished must always be heard. So you don't condemn somebody without hearing what they have to say. Everybody deserves a defense. Another principle of natural justice is that you should treat like situations in a like manner. So if someone does a crime under the same circumstances, his punishment should be identical to another person who does the same crime in the same circumstances. So you treat like cases like. These are aspects of procedural justice that, despite the quite unjust substantive nature of the laws of the British Empire, were nevertheless adopted into British legal tradition. So what Gandhi realized that he could do was that while substantively the law was unjust, he would not bring challenges to the racialized notions of substantive justice in South Africa. Rather, he would bring challenges at the procedural level, and he would ask whether the Indian, he always represented Indians in this early period, whether the Indian who was under trial was being treated according to the principles of natural justice that are so crucial to the jurisprudential thinking of British law. And he managed in this way to get bail or even dismissal of cases against his clients, whom he never would have managed to achieve this outcome if he had just challenged the substance of the law head on. So this experience taught Gandhi the way to negotiate between procedure and substance, and this turned out to be crucial in the way that he negotiated with the representatives of the British Empire throughout his later life. In Young India, Gandhi also makes very specific distinctions between the injustice of the law in correlation to the principles of natural justice, which would seem to demand another procedure by the British rulers. The last point to be made about this innovation that we called Law as Journalism Exposing Injustice is that Gandhi used Young India as a way of informing the public about his own experiments with the law, specifically the sedition trial that we'll speak about next. As the trial is ongoing, Gandhi publishes all of the texts, the transcripts that are available to him about what is said by the court, and of course his own defense. And this allows the general public to get in touch with what's going on in these closed courtroom doors. So let's move on to the fourth way in which we see that the legal education that Gandhi had and his experiments with legal reasoning and legal practice informed his conception of the law beyond what critiques he makes in Hind Swaraj. And this is the sedition trial. In the sedition trial in Ahmedabad in 1922, Gandhi was tried under Section 124A of the IPC on the charge of exciting disaffection towards the government established by law in India. This exciting disaffection or causing disaffection was converted by Gandhi from a crime into a moral duty, what he called the highest duty of the citizen. This is an extremely interesting way that Gandhi managed to turn the tables on what was supposed to be law and justice, and he established through the eloquent defense that he made that the law was unjust and it was the highest duty of the citizen to violate that law in order to be just. By doing this, Gandhi managed to create an environment that Sudipt Kaviraj described as one where the rebel is on trial, to one where the state is on trial by the rebel. In other words, the theatrical maneuvering that Gandhi made in terms of the way he negotiated with the judge and prosecutor turned the tables such that people now felt it wasn't Gandhi that was on trial for sedition, but rather the British Empire that was on trial for failing to live up to its obligations. When Gandhi disobeys the law, he's reaffirming the fact that the law must have an integral connection to justice. It can't just be arbitrary law, arbitrary rule for the sake of the rulers, but it must be ultimately grounded in justice, and that means, of course, equality for the ruled as well as the rulers. Gandhi is asserting that law can't be linked to violence, it can't be linked to force, but instead its only legitimacy is when it is grounded in justice. Now, the link that Gandhi throughout his life draws between politics and spirituality, or the world of contemplation and the world of action, can be read by us now as a call for a link between legal philosophy and legal activism. In other words, if we see these four modes through which Gandhi breathed life into the lessons that law can provide, we can follow up on that in Gandhi's thought and see that legal philosophy and legal activism can be united through a quest for justice. Furthermore, there are striking resonances between the Gandhian practice in colonial South Africa, where he was an early human rights lawyer, his practices in colonial India, where he became a satyagrahi and a practitioner, and the current condition in independent India, where we learn from Gandhi creative ways of engaging with the law. So much beyond Gandhi's critique of the law and lawyers in Hind Swaraj, his practice of the law throughout these differing phases of his life, before and after writing Hind Swaraj, show us that law can be engaged with creatively and justice can be wrestled from the state, even in scenarios of gross injustice. In that respect, Gandhi's approach to law irrespective of what he wrote about it in Hind Swaraj, can be deeply inspiring for contemporary human rights practitioners and other activists who need to find ways of engaging with the law and find ways of doing that creatively despite possibly repressive systems of governance. Finally, Gandhi had to be both an exemplary practitioner of human rights as well as a critic of human rights who aimed to transcend the limitations of human rights activism. That is to say, he was not satisfied with merely articulating his concerns, but he had to get completely engaged in the practice. He went from being an advocate for those who were suffering injustice to being a criminal in the eyes of the state through the process of fighting that injustice. In all of these ways, Gandhi's relationship to the law show us that the picture he portrays in 1910 in Hind Swaraj is not the end of his views on law. Rather, throughout his life, the engagement that he had with the law was far more complex than the condemnation that law and legal practice receives in Hind Swaraj. Thank you.